of San Francisco to have a landlord tenant law, and we're grateful to have him here today. Daniel, thank you very much.
Thank you for inviting me here. Let's jump in. So I've got an hour of your time. First of all, thank you very much for inviting me. It's my pleasure to be here. Let's use the hour effectively. What I'm going to do is go over what I think are core issues that real estate agents in San Francisco should have a working knowledge of. And one of the ways I do this is I create cheat sheets that make things that are typically complex and reduce it to a digestible format. And my hope is that after you come away from this hour event, you've got a better working knowledge of the ordinance and how I think the best real estate agents in the city are able to look at a property and be immediately able to segment it and know what's possible, what isn't possible, and then I will add complexity. And at the end of the discussion, I'll open myself up to questions and answers. I'm going to be going through a PowerPoint slide presentation. You have a PowerPoint slide presentation, and you also have hard copy, hard stock, so that you can use, laminate it, whatever you want to do. Distribute it to your clients, distribute it to other real estate agents. My goal is to educate people and get you in a position where you can look at a property and say, this is what we can do, this is what we can't do. So I'm going to proceed pretty rapidly, but it's, I think, going to be extremely helpful as a refresher or simply as a learning process. So let's begin. I'm going to quickly go through these core subjects, and I'm going to touch upon them. I can't give an exhaustive review, but I'm going to go over what I consider to be the core aspects of each. The most important thing is, if you're a real estate agent in San Francisco, you've got to be able to understand what is subject to the rent ordinance and what isn't subject to the rent ordinance. And if it is subject to the rent ordinance, you've got to be aware of the just cause eviction rules, the owner move-in, relative move-in, protected tenant issues, how and under what circumstances I strongly recommend buyout agreements, why I recommend them, and how you do them properly, not you but your clients. I'll talk quickly about ADUs and what's happening as I see it on a day-to-day basis. I'll touch upon COPA. I was here about 3 weeks ago with the commercial agents talking about COPA, and it's getting obviously more and more prevalent as we get closer to the September start date. My hope is that the discussion is academic because someone challenges the law, but I want to just give you a little bit of an insight, and then I'm going to answer questions you have on any of your matters. This rent control cheat sheet, I always start a discussion with the rent control cheat sheet, because when we talk about San Francisco, you've got to be able to delineate what is subject to the ordinance and what is not subject to the ordinance. When we talk about a property being subject to quote-unquote rent control or just cause eviction rules, you have to remember there are two components of the rent ordinance. There's rent control and there's just cause eviction rules. Some properties are subject to both, some properties are subject to neither, and some properties are subject to rent control but not subject, subject to just cause eviction rules but not subject to rent regulation. This chart provides the clarification for you. So we start at the bottom of the chart, and we say, when was the property built? If it was built, the certificate of occupancy was issued after June of 1979. There is no rent control, no just cause eviction rules, no protected tenants. Got it? That's easy. So you segment this chart, and we have it in hard copy as well. So for those of you who want, there's a better copy of it behind here, the cheat sheet. Or should, yeah. So the first thing you want to remember is, look, if you're looking at new construction in South of Market built in 2010, we don't have rent control, we don't have just cause eviction rules, we don't have protected tenants. We simply have tenants on a fixed term lease or month to month. Got it? Whenever someone calls me in my office and says, hey, Mr. Bornstein, I've got a problem with a tenant there, we're having parties, they're subletting, it's a terrible situation, the first thing I ask is what? When was the property built? I have to put myself into this chart to know what I'm going to do. So if new construction, no problem. What is new construction for San Francisco? Post-June 1979 property. Certificate of occupancy issued after June of 1979. If you're wavering and you don't know, there are some properties that are wavering or wobbly, you've got to go and get occupancy or the certificate of final approval. This is easy. If you don't want to have a stressful life, go ahead and focus on properties built after 1979. South of Market, new construction. Let me mention something very important. A duplex built in the 1930s that was converted to condos in 1985, that is still going to be this part of the chart. Got it? Let me say that again. A multi-unit building built in the 1930s but converted to condominiums after 1979, we're still treating it as what? Pre-79 property. A lot of people don't realize that. Generally, south of Market, the vast majority of properties are built before 79, but there's an emerging group of properties that have been built after 1979. No rent control, no just cause eviction, no protected tenant. Doesn't matter if it's a single-family home, a condominium unit, a duplex, or a triplex. No rent control, no just cause eviction protections. The top part of the chart is where it gets tricky. Pre-1979 properties, duplexes, triplexes, sixplexes, 10 units, 20 units, 30 units, single-family home with an in-law unit built before 1979. You have rent control for multi-unit properties and just cause eviction rules and the risk of protected tenants and obviously relocation payments. So if you've got a duplex in the Sunset that was built in the 1940s, you've got rent regulation, you've got just cause eviction rules, you have relocation payments, you have protected tenant risk. If we have a single-family home or a condominium unit, this is where it gets complex. If it was built before 1979, that single-family home and condominium unit is going to be subject to what? Just cause eviction rules, but not necessarily rent control. That's Costa-Hawkins. And we know in November they were trying to eliminate Costa-Hawkins. So whenever I'm looking at a property in San Francisco, the first thing I'm saying is, when was it built? I know either bottom or top. Then after I say when was it built, I say, is it a single-family home, a condominium unit, or a multi-unit property? If it's a single-family home or a condominium unit, I may have what? Just cause eviction rules, but no rent regulation. Which means, for you Compass agents, there will be properties that are mismarketed in San Francisco where you have an out-of-city agent listing a single-family home saying subject to rent control and tenants' rights, not realizing that that property is not subject to what? Rent regulation. Which means you as a buyer don't have to do an owner move and eviction, don't have to necessarily do a buyout. You can simply come in and raise the rent to market rate, which gives the buyer either market rate rent or maybe a vacancy because the actual tenant decides they don't want to pay that market rate for the property. Be advised, lots of complexity when we're dealing with a single-family home and an in-law unit. Where we have a single-family home and an in-law unit, two separate tenancies, that is a multi-unit property for purposes of this chart. Where it gets complex is where you have a single-family home and then an in-law unit that was recently vacated and you're marketing it for sale. The single-family home looks fine and the in-law unit looks fine. You're marketing it as quote-unquote bonus room. The question is that a multi-unit property or a single-family home? Generally, you have to restore the unit to a single-family home status in order to be free from just cause eviction rule, from rent regulation. Got it? I want to see a clean, pure single-family home, not one with two separate addresses. Or not one that has a completed unit down below that has recently been vacated, because the tenant is upstairs going to immediately say, look, this is a multi-unit property. There was always someone down below. That's where it gets complex, but most importantly for you folks is being able to see this chart and after today immediately say, okay, now I've got it. I'm going to look for pre-1970 properties or after 1979 properties and I can place them in here. And for pre-1979 properties, I'm always asking myself, is it a multi-unit property or a single-family home or condominium? Got it? Perfect. So if we have a pre-1979 property, doesn't matter if it's condo, a single-family home, or a multi-unit property was built in the 1950s, you're subject to just cause eviction rules. You have to have a just cause to evict. Non-payment of rent, breach of lease, nuisance, illegal use, owner move-in eviction. relative move-in eviction, Ellis Act, removal of a unit, capital improvement terminations where you can remove a unit temporarily to do a capital improvement and the tenant has the right to come back in. These are the just causes, and one of the things that for real estate agents you have to recognize that many of your clients don't, is a just cause the desire to sell a property vacant? No. So many times you have a client who has a single-family home or a multi-unit property, they live in Missouri, and they call you up and say, please list this property, and the tenant's month to month, it's an old lease agreement, we'll serve a termination notice, and they'll be done. And you have to say, hold on, when was your property built? Oh, 1930s, it's a lovely building out in the Richmond district. And you have to say, I think you ought to talk to an attorney about what's possible and what's not possible. And then I have that hard dialogue with the client who I then call up and they say, hey, Mr. Bornstein, please terminate the tenancy. I'm going to sell the property. My family's going to cash out and we'll be thrilled if you can help deliver the unit vacant. I say, when was your property built? Oh, 1940s. They say, do you have a lease agreement? Yes, it's month to month. Just serve a termination notice, Mr. Bornstein. I say, I can't serve a termination notice. They say, why? I say, your property is subject to just cause eviction rules. The desire to sell a property vacant is not a just cause to evict. And they say, what? The lease says month to month I can serve a 30-day notice. I say, I'm sorry, you're operating under the umbrella of this regulation. It doesn't matter what your lease says. Got it? And those are the type of dialogues I have many times with your clients, and I'm happy to have it. Then they swear, right? And I say, well, we're not out of options. We can always potentially negotiate a voluntary move out through a tenant buyout, right? I just can't serve a termination notice because you don't have the right, you haven't articulated a just cause to evict. Delivering a unit vacant as you market a property for sale is not a just cause to evict. And then they say, well, Mr. Bornstein, I'll do an owner move and eviction, and then once it's vacant, I'll turn around and sell it. I said, well, you have to live there for 3 years. You live in Missouri. I bet you're retired. He says, oh, I have to live there for 3 years? I said, yes. So those are the type of dialogues that we probably all face as people sort of creatively think of solutions to the problem, and I have to either reject them, suggest an alternative, but we're in the same business, which is we manage relationships, we have difficult dialogues with people, we give them what they can and can't accomplish, and we temper their expectations with the reality of the situation. These are the just cause evictions. They don't apply if it's a post-1979 property. So if it's a new construction in the millennial building, and the tenant is a month-to-month tenant, they've lived there over a year, all I got to do is serve a 60-day notice of termination of tenancy. If they've lived there under a year and are month-to-month, a 30-day, I don't have to give a just cause. I simply serve a termination notice. And the example of the ease between a non-just cause eviction jurisdiction or a rent control jurisdiction, a termination notice in South San Francisco is about 3 paragraphs, right? A owner move and eviction termination notice in San Francisco is 16 pages. Right? And if you make a mistake on the termination notice, you have to start over. And so tenant attorneys get good at looking at mistakes in your notice because they know they don't really have a defense to a new owner wanting to move into a property. They find a technical mistake in the notice, and that's where it gets, you get forced to start over again. And the whole goal of that brief discussion is if you have a client who's seeking to do an owner move-in termination and they say, hey, I got a cousin in Stockton who does real estate law, that's potentially dangerous because the law is so complex here. You have to be very niche specific about what you can and can't do because these notices can create all sorts of crises if they're not done properly. All right, so relocation payments. In San Francisco, if we're dealing with a just cause as a no-fault eviction, what are the no-fault evictions? Capital improvement termination, owner move-in eviction, relative move-in eviction, removal of an in-law unit from housing use, you have to pay relocation payments. And why I bring this up immediately is, and I didn't think I thought I brought enough, but I'm going to give you more. Here you go. Here you go. And anybody who doesn't have this, if you just email me, I'll get you a whole package digitally to you. If I'm going to do an owner move-in eviction on a duplex and it's the top unit, and the tenants are month to month, and they've lived there 2 years. It's 2 adults who are in their 30s, they're healthy and otherwise just fine. They've been there a couple years. How much money am I gonna have to pay them? $6,980 each. Half at the time of service of the notice, half when they vacate. It gets complex though. Let's say if we have 4 people in the unit, 2 adults and 2 children, the children are school age. I would have to pay $20,939 to the 4. It maxes out at this amount. So once you get more than 3 people who have lived there over a year, it maxes at this figure. But then we have to go to the next column and ask, are there any elderly people? No. Are there people with children in the unit? Yes. They get another $46.54. Half at the time of when they make the request and half when they vacate. So on that example of 4 people in the unit, 2 adults and 2 children, we're looking at about $26,000. Change the dynamic. 3 people in the unit, 2 adults who are over the age of 60, they're 62 years old, they only lived there 3 years, so they're not protected. And they also have a child who they're taking care of because they've got custody of one of their children's, one of their grandchildren. What do we have? $20,939. Because they're a family unit that has a child in there, another $4,600, and then each of them are over the age of 60, so they got another $4,600, $4,600 each. Yes. So what we're looking at is what? Another $15,000 from this and 20, so we've got a $35,000 payment. Why I mention this is because your clients need to be familiar a little bit with this, because if they haven't saved the money to put aside for an owner move and eviction and the relocation payments, they're going to be very, very upset with you that you didn't sort of forewarn them. I've given you an owner move and eviction package. I want you to buy and be comfortable recommending to buyers they buy a property that's tenant occupied. Why? Because only 2% of the city isn't, right? And 2, those properties tend to be priced lower than what they would be worth vacant. And if you have an effective, efficient OMI process, the vacancy creates upside in the building immediately upon renewal, right? And we all know that vacancies are now being arbitraged. Vacant space has a value in San Francisco, and oftentimes the price of a property with tenants in it are muted in a way that isn't reflective of the upside that you can generate simply by effectively handling an owner move eviction. So if you need to provide this tenancy $35,000, you ought to know it when you're making an offer in contract in order to actually make sure your price point takes into account this cost and this risk. Now this applies to all pre-1979 properties, whether it's a single-family home or multi-unit property. If it's built before 1979, you've got to do this relocation payment. It applies to relative movements, owner movements, removal of an in-law unit if you can get the permits, and also capital improvement termination. So if you're going to renovate a bathroom, renovate a kitchen, and there's 3 people in there, you may be paying $35,000 to do a renovation project and $35,000 to do a displacement temporarily. That's one of the critiques of rent control, which is it ends up becoming so onerous that people are not interested in actually keeping up their units, especially if they know they're paying this type of relocation payment. And then after you complete the capital improvement, do you get the rent increase automatically? No, you have to petition the rent board for the capital improvement passes. So I'm going to take questions at the end. Let's go over the OMI chart. This is relatively new stuff, and I have this in a hard copy for you as well because it's so important for your clients to understand what their responsibilities are. And how many of you remember about 18 months ago there was a news investigation where news investigators, journalists went to different homes that had done owner move and evictions. They knocked on the door and they tried to find out if the owners were still there. And they made this huge hoo-ha about that the owners weren't there. And as a result of it, the supervisors then clamped down and made it especially even more rigorous to complete your obligations for an owner move-in or relative move-in eviction. Let's go over this so your clients who are buyers understand what the rules are. If I buy a property that was built before 1979 and there's a month-to-month tenant in there and they've lived there 2 years and I can't buy them out, I'm going to do an owner move-in eviction. The first promise I have to make is to live there for 36 months. Before I do a termination of tenancy for the client, I tell them to get wrongful eviction coverage. Because I'm sure they have good faith to move in, and I'm sure at the time they serve the notice they want to live there, but then they get transferred to New York for a job and they don't live there 36 months, and all of a sudden they move out in good faith because of a job opportunity. The tenant who they displaced didn't know about that and they filed a lawsuit. We want to have wrongful eviction coverage. You have to promise to live there for 36 months. After 36 months, you're free to sell the property. You completed your obligation. However, if you move out on the 36th month and you decide to re-rent the property, you have to offer it back to the tenant you displaced at the old rent amount from month 37 to month 60. 37th month to 60, you have to offer it back. And once you offer it back, if it's a multi-unit property, what are they subject to? Rent control. If the tenants you displaced do not want the unit on month 37, you have to offer it to the public at the old rent amount, from month 37 to month 60. So what this means is as follows. For your clients who are new purchasers, most of the time who are displacing to an owner move-in eviction, generally speaking, they want to make a commitment to be in that property for how many months? 36 months or 60 months? 60 months. So you really want to, unless they're buying and they're pretty clear that they're buying and they're going to live there 36 months and then they're going to sell, you can sell it, deliver it vacant. The new owner has to do what? Either move into the property, or the new owner is going to rent it out, has to what? Comply with the new owner's obligations to these people as well. Which means that you've got to have more historic knowledge of what's going on the property than we did many years ago. Understand? This is the new burden of owner move-in eviction relative to move-in evictions. It's relatively recent, within the last 24 months. And you have to file documents with the rent board on a consistent basis, letting the rent board know whether the unit is vacant, whether it's been offered for rent, or whether you're still in the unit. You don't fill out those forms, they send you notification that you're in violation and penalize you $250. How do they know that you did an owner move-in eviction? Because when I serve a termination notice, I have to file it at the rent board within 10 days or I lose the case. So what's happened is the information is being sort of streamlined at the rent board so that you're not able to, on month 37, turn around and rent it out at market rate and lock it at upside. 60 months is really the commitment, unless you're going to sell the property or you can let your friend live there. But what this looks like is as follows. It looks awfully like some of the obligations that an Ellis Act imposes upon people, which is an Ellis Act, you can't rent out a place for market rent until month 60 as well. The goal was, in essence, to make it a bit more of a deliberative process to decide if you're going to do an owner move-in, because you're really committing to 36 months of living there and then another 2 years of not re-renting at market rate. You can sell it, you can continue to live there, but if you rent it out at market rate, you're in violation of the law. You can be sued by the tenant. If the tenant, the new tenant, finds out about it, they sue you for wrongful eviction, or they sue you for a disgorgement of the rent that you collected over the amount you're entitled to, and they file a petition at the rent board for a reduction of the rent back to the original amount that should have been. This is really helpful for you. I think I've done a good job of clarifying it. Remember, if the building was built after 1979, we don't worry about this. There is no owner move-in evictions. We simply terminate on a month-to-month basis. And oftentimes for you who have clients who are in the Millennial Building or somewhere south of Market or by the ballpark, you've got a tenant who writes that they're subject to, they're protected tenants, or they've got some sort of affirmative protection under the ordinance. They don't realize that because it's new construction, it has no impact on a new buyer's rights. What happens to you as a seller's agent when a tenant, by mistake or intentionally, fills out a form claiming they're protected when they can't be protected because they're in a building that's post-79? Come to me. I'll write a letter that you can include in your marketing plan that says, even though the tenant has asserted that they are protected because the property was built after 1979, it falls outside of these protections and the tenant is simply misinformed. When a tenant does something that is intentionally intending to harm the sales process, then I may write them a letter saying they need to rescind their claim of protected status because they're interfering with a business relationship and they can expose themselves to litigation for interfering with a business advantage, which is a tort. So there's many ways to handle it. What you don't want to do is sit in a situation where you're not able to accomplish a sale because of misinformation that's been presented out there. And there's lots of misinformation out there. Okay, protected tenant. Let's go over protected tenant. There are no protected tenants in a single-family home or a condominium unit. No protected tenant in a single-family home or a condominium unit for these type of protections. No protected tenant in a single-family home or a condominium unit. Meaning that if I have a woman who's 75 years old and has lived in a single-family home for 12 years, I can still effectively do an owner movement eviction. I would have to pay her relocation payment and an additional payment because she's older, but I'm still able to terminate under that theory. This chart is when you're not able to successfully terminate a tenancy because someone's protected. Let's go over this. We know post-1979 property, there are no tenant protections. We don't have to worry about that. Pre-79 properties, the vast majority of properties, if we have a multi-unit property, the protected tenants are what? 10 years and over the age of 60, 10 years and disabled. And put on an asterisk for disabled, it's typically eligibility for SSI. It's a high standard. In the relocation chart, 2 charts before, disability payments for someone who's disabled is really low. So I'm paying disability payments for people who have anxiety and they're on Ativan, or people that have arthritis. Because if you don't pay it, you can lose the case because you haven't complied with your obligations. But a protected tenant who asserts that you can't displace me because I'm protected, they have to be typically eligible for SSI. The next category, go ahead.
If they're 60 years and they've been there 10 years, they also have...
No, that's one category.
That's one
Yeah.
category.
60 and over 10 years in occupancy, disabled, which is eligibility for SSI in 10 years, or catastrophically ill and 5 years in the property. Most tenants who qualify for this scream it in their disclosures. It's the tenants who don't fill out the disclosures that want to create ambiguity for you that causes people to say, well, wait a second, this person's been there 12 years, how old are they? Wait a second, this person's been there 20 years, are they working? And what I'm finding is that I got to do a lot of background search for buyers, which is we hire a private investigator who does a database search to find out people's ages. We have a private investigator who will find out who's in fact living in a property because your seller from New York lost the lease agreement, doesn't know who's inside the place, and you're concerned as an agent that you don't want to set up your buyer with a protected tenant situation. So what I always do is if you have ambiguity in that information, you take a deep breath, don't remove the contingency and say, I need more information before I do it. And your buyers will be respectful of that need because your buyers understand that if they buy a property that has a protected tenant in it, you may not be able to displace them through an owner movement eviction, and their only other options are buyout or Ellis Act, and they can be very, very expensive. And what's happened over the last 8 weeks, 12 weeks, is all of the owner movement eviction notices are now being sent to the Tenderloin Housing Clinic. They've put together some more attorneys, and now they're handling the defense of owner movement evictions, which means it's that much more cumbersome, challenging, and difficult, because their goal is to make it as expensive as possible in order to actually put people in a position of having more difficulty recovering possession of their unit. And it's particularly painful when they have to bring in young people or any people who have bought their first property, stretched to the max to buy their first property, and say, hey, you've got an issue, which is they're going to be defending this lawsuit, and it's going to be a grind, and you need to be mentally and emotionally and financially prepared for it. I have to supplement this chart with this academic year rule. What is the rule about the academic year? If there's children in a unit, or the Tenants work within the academic industry in San Francisco. You can only terminate the tenancy where the notice expires during the summer months. So if there's children in the unit, or there's teachers, custodians, teachers' aides who live in the unit, you can only serve that termination notice so it expires in the summer months. Guess what today is? Today, June 17th, is the last day I can serve owner move-in, relative move-in notices for those people who have children in the unit. So I've got 3 or 4 of them that they closed escrow in the first week of June, and we're doing this notice quickly to get it done because it has to expire before what date? August 19th. August 19th is when the school year starts.
Is that public?
San Francisco. San Francisco. So if you're representing a buyer and they're buying a unit that has children in it, you gotta wait until next year to serve that owner move-in eviction notice. I can always serve it in February and give them 180 days. What I have to do is the notice has to expire between the end of the school year, which was like May 31st, and the beginning of the school year, which is August 17th, 19th. Go ahead.
What about if the people that are buying it have school-age children and or the same?
Used to be an exception, it's no longer an exception.
Gotcha.
It used to be an exception, it's no longer an exception. It used to be single-family homes and condominium units did not fall within this. Now all of them fall within it. So it's pretty tricky, and here's the thing, with all sorts of wonderful diversity in San Francisco, you can't be sure if there's a child who's living in the property because they can share custody. You may not see the child in the unit. They may not have told you that there's a child when they fill out the estoppel, and only after the fact do they tap you on the shoulders and say, we share custody. We have an extended family. We have a situation where a child is indeed in here and we have responsibility for it. So you really need to know what's going on in the unit, and sometimes it's not that easy to discern. But
Some of these schools, these alternative schools, have very different dates and they run almost.
it's based upon the San Francisco
So
Minnesota.
that's everybody's.
Yeah, August 19th is the date. And for me, it's nerve-wracking because if my process server can't, you give me a key and they can't open the door today, and they can't serve it, I gotta tell the client, we got a problem, we haven't been able to serve it, they're gonna kill me. So I'm in the same boat. Why I bring this up is that you need to know what's going on in that unit so carefully. And if you do have children in the unit and you are a seller and there's a goal to actually have this place sold, and you know that the vast majority of people are going to buy the property because they want to move in because they can't afford to keep it as a rental, well, you have options. And what's happening in the city is this. Every time there's a new statute, every time there's a further regulation in San Francisco, it pushes people to seek buyout agreements as opposed to litigation. So what's happening in my practice is I'm doing buyout agreements all the time. If a person is willing to vacate in exchange for compensation and it's within reason, it may be a much easier choice than to proceed with an owner move-in eviction or relative move-in eviction. And when I'm marketing a property for sale, of course, you agents will be able to discern what the place would be worth vacant versus what the place is worth tenant occupied. And I often have this interplay with clients. They'll call me up and say, Mr. Bornstein, if my realtor referred me over to you, we want to talk about the potential of a buyout. What's the range or what's the market price? And I say, look, I don't know what the range is. My goal is to get you the place as fast and as cheap as possible. But you need to talk to your agent as to what the place is worth vacant versus tenant occupied. There can be swings of 50,000, 100,000, 150,000. You are tasked with that knowledge. My job is to just say this. They say, well, how do we determine what is the price we should offer? Generally speaking, I want to get close to the relocation payments amounts, $6,800 per person. Because I'm going to tell the tenant, hey, if we sell the property, a new buyer is going to come in and do an owner move eviction, you're entitled to $6,800. We'll be willing to waive 2 months' rent and give you $9,000 or $10,000. So that's the base. The tenant attorney who's smart says, Mr. Bornstein, your
client is gonna make $150,000 more selling it vacant. We'll take $95,000 and please give us 2 months of the rent waiver and security deposit return according to law. Do you see how it works? So the difference in the ranges between what the place is worth vacant and what is the relocation payment, and somewhere in there is where you get that deal done. Sometimes it's cheaper, sometimes it's more expensive. It really depends. And one buyout discussion doesn't inform the other, because there are some tenants who simply, they're not interested. For example, you have people who are living in an area where they're very, very comfortable. They may only speak one language, they don't speak English. They've been there 30 years. They don't want money because they are happy where they are. They have a stable situation, a rhythmic life, and displacement into a different community has too much trauma for them. So you simply don't have the ability to actually get to the deal. All things being equal, if I'm representing a seller, before I start marketing the property for sale, I would love for my seller to consider negotiating a deal, because we know easier to show, easier to stage, of course, sells for more money. What do I do if I'm an agent? I get a long listing agreement. Instead of a 90-day listing agreement, you say, look, we're going to first, I want you to understand that the place would be worth more money if it was vacant. Let me have an opportunity for you to go to an attorney and figure out if you can do a buyout. With the guidance of an attorney, let me get a 6-month listing agreement, because if I'm going to negotiate a deal for a tenant to move out, when do I want to stage and sell the property? After they're gone. I don't want to deliver the place vacant at close of escrow, because then the tenant controls the sort of sales process, and you're at risk of a tenant breaking their leg, not moving out, deciding that the deal is no good, so they rescind the agreement. So I generally want a long listing agreement. If I'm representing a buyer on a transaction, and they are not going to be able to do an owner move eviction because they live in St. Francis Wood and they just bought this property because it's a fixer-upper, then we're going to have to negotiate a deal. Sometimes the buyer doesn't want the rigors and obligations of an owner move eviction. So if a tenant is entitled to $25,000 in relocation payments, 2 tenants with a child or something, it may be cheaper, faster, and smarter to pay $35,000 or $40,000 to obviate the responsibility of having to do an owner move eviction. You understand that? So if we go back to the chart, and I don't know, right, if we go back to this chart, and you know that this person has to re-rent it on 137 at the old rent amount, it may be worthwhile to give someone $50,000 to give up possession, as opposed to obligate yourself to do an owner move eviction. If there's 3 tenants in there, and remember, if you do a buyout agreement, do you have to live there? No. Do you have to re-rent it in the past or in the future at old rent? No. Buyout agreements give you maximum flexibility. And that's why I'm much more favorable to buyout agreements. And we're doing them all the time. And so if I had to save my client the aggravation of doing an owner movement and recommend they pay $15,000 more than the relocation payments a tenant would be due, it may make good sense to do so.
And what are legal fees?
Good question. Legal fees. Buyout agreements. Let me just say this. Remember, there's a 45-day right of rescission. So even if you sign an agreement with the tenant, they have 45 days to change their mind. And then you say, well, how are they going to know they have 45 days to change their mind? By law, you have to include a bolded statement in the buyout agreement that you have 45 days to rescind. So they get informed as a result of your obligation to draft up a good buyout. Generally speaking, I haven't had many people rescind. It does happen though, right, Josh?
Yeah.
And yeah, generally, if you get to a deal, most people want to live up to their obligations. They feel empowered by the process. It's not trying to take advantage of the situation. It's trying to meet people at the point where they want to be met. And if you do and drive too good of a deal and go and get counseling, the person will say, hey, that's not a good deal. You're less than what the relocation payment would be. So why would you do this and move out if you can get this amount of money and have them do an owner move eviction? Double it and it makes sense. So that's sort of the behind the scenes look. I don't negotiate the buyouts. There's a disclosure obligation that needs to be provided. Any of you who want, just email me and I'll send you the PDF
PDF of the San Francisco Rent Control Disclosure Obligation. I don't do the discussions with the tenants because if I reach out to a tenant, they Google my name, they see I'm a landlord attorney, they call up Joe Tobler, and all of a sudden my reach out to the tenant ends up creating a more expensive buyout for the client. I want to do no harm, so I generally want the client to do the discussion and simply send me this information by email to me, filled out. Then in 48 hours I'll prepare a buyout agreement. Fixing $750. As long as I'm not doing multiple iterations of the agreement and negotiating or having them get an attorney. If it's simply, this is the deal, name of owner, name of tenant, address of unit, when are they vacating, how much, when are you paying them, what about the rent, what about the security deposit, I can draft it up rather quickly. And this is in the materials.
Go ahead. Two charts back, you
Yeah.
mentioned, so I buy a unit 37th month, I sell it. The new owner still has the next 2 years.
Yes, you stand in the shoes of the former owner, but the new owner typically buys the property to do what? To live in. So it's no problem for a new owner to live in. It's the problem if they decide to rent it out at market rate.
So new buyer buys it a year later, gets transferred. It's still in effect. How do you notify, I guess you just have to notify the new owner
When
on
in
the
the sales,
37th to 38th month.
right, and all of your disclosure will potentially include how did the unit get last vacated, and if you're representing an owner who had recently done an owner move and eviction, and they're on their 4th year, you want to potentially tell them, look, this property is available for you to purchase. Consult an attorney about the risk and responsibilities you face as an owner purchasing this property. It's not your obligation to educate them about the law. It's your obligation to let them know they need to be educated about the implications of it, right? What you can't do is say, hey, once they leave, you'll get a market rate on this, and this is what the market rate for it is, because that's incorrect information. Because they're supposed to, for the first 60 months, still offer it to a new tenant at the old rent or the former tenant. And simply because you sold it doesn't alleviate the obligations, because as a new buyer, or as a new purchaser, you stand in the shoes of the former landlord. Now, this is new stuff. How many people are going to have that historic knowledge to make sure they do this? I don't know. Someone will get caught, right? But the goal is for you to be aware of it and understand the potential risk. The rent board will have the documentation because the buyer, the owner who did the owner move and eviction is required to notify the rent board on a twice-a-year basis what's going on with the property. You're entitled to sell it, but the new buyer will have a responsibility for it. So let's go back here for the buyout agreement. I said I'm doing them all the time. It got so busy I have an attorney who works from home drafting up these agreements, because for you as a seller's agent, it's so much easier to be able to pay someone to move out, because you're usually able to get that upside back in the property by virtue of the vacancy. And sometimes I've done deals for a seller where the tenant moves out early and we deliver the payment within 48 hours of close of escrow. And then we put a fixed date not to extend past September 1st, 2019. So sometimes if your client is house rich and cash poor, I can negotiate something where the tenant will vacate early, but that depends upon their obvious willingness to do so. Okay. So let me do this real quickly. Remember, if we're going to be buying a property to do an owner move-in termination, we're going through the eviction process. It's an unlawful detainer action. It's the same whether we're in San Mateo County, Los Angeles County, San Francisco. Once we go into the eviction lawsuit, we're not at the rent board, we're at the municipal courts. So if the tenants live there over a year, I would serve a 60-day notice. I give half the relocation when they serve the notice, half when they vacate. If the tenant moves out in 60 days, we're done. I'm thrilled, client's happy. They write a wonderful Yelp review about me, and I'm thinking in the back of my head, you got lucky. All I do is payroll, right?
And you know, as all of us know, sometimes your best work, the client doesn't even understand that you've done great work for them. And sometimes they're projecting great work when it was luck. And so I serve a 60-day notice, if the tenant moves out, great. I'm happy, they're happy, they move back in. If they don't move out, then I have to file what's called an unlawful detainer action. The tenant is unlawfully detaining possession of the premises. This takes 6 to 8 weeks to work itself through. So if I'm doing a 60-day notice and then I have to do another 6 to 8 weeks for an unlawful detainer action, 4 months from the time of purchase till you're going to get control of your property. And meanwhile, you pay $22,000 of relocation payment. My retainer for an owner move and eviction is $7,500. You're paying a mortgage. You're paying rent at the current place you're living, and you can't collect rent from the tenant after the notice expires, because if you collect rent, you reinstituted the tenancy, and so you've got to start over. So you need a pot of money on the side in order to be able to accomplish the goal of this. 6 to 8 weeks, 95% of the time the case will settle with the tenant moving out. Moving out in exchange for something. Relocation payment, of course, because they're entitled to it. Maybe a rent waiver and an additional few $1,000s in order to leave without forcing you to go to trial. The problem with this whole process is that when you get to the settlement conference, you're still looking at maybe a trial that could take 3 to 5 days and cost an attorney fee amount to $15,000, $20,000. So that if a tenant attorney says, Mr. Bornstein, I know they made it difficult for your client to move in, they'll ask for another 60 days and give them an extra $5,000, right? Their rent is $2,000, so 60 days is another $4,000 of lost rent, plus another $5,000 additional beyond the relocation payment. And guess what? It's cheaper to do that than potentially what? Go to trial. So you're always in a situation where you're arbitraging the cost of litigation versus getting closure on the relationship. Back up. If before I serve this termination notice, the tenant says, look, Mr. Bornstein, we're entitled to $6,800 each. You give us an extra $10,000 and we'll leave in 30 days. And we'll sign a release and do a buyout. What looks more attractive, going through this process or giving them an extra $10,000? Your clients are paying a mortgage of $4,500 to $7,500 a month. It may be cheaper to give someone $10,000 than to actually deal with the consequences of litigation. And I'm all about as fast and as cheap as possible to get the place back, because that's where we do well for our clients. We don't like disputes. We like closure and accomplishing a goal. I say this usually for many people. Disputes are not like a basketball game where one side wins and one side loses. All I'm trying to do is accomplish a goal as fast and as cheap as possible, taking into account attorney fees, time, and risk. And if I can do a buyout for approximately the cost of an owner move and eviction and get a complete release where my client doesn't have to do any of the regulatory filings at the rent board or have to promise to live there for 36 months, it's easy. The only problem is this, and then I'll end it. So the tenant comes to me, they have a child in the unit, and it's now May 15th. They have a child in the unit, they're month-to-month tenants, and they say, Mr. Bornstein, we'll do a buyout agreement, and all we want is an extra $5,000, and we'll leave. If I do a buyout in May 15th, where they're going to leave at the end of June, and they have a 45-day right of rescission, if I do the buyout agreement, and then on June 29th, the 44th day, they say they change their mind, guess what? Can I do an owner move and eviction? No. Because they rescinded and now I have to wait another year. So that's the type of sort of thinking 3 moves ahead that I am tasked with doing for a client. I have to say, we can do a buyout, but if we don't serve that notice and they change their mind at the end of June, you've got yourself another year here. What do you want to do? And most of them are like, do an owner move and eviction termination notice. We'll discuss how they're going to transition out, but we're not going to take the risk of losing that full year. And right now there are people in contract who didn't have good counseling and don't realize that the day after they close escrow, they're going to go to a landlord attorney and the attorney's going to ask them, do you have children in the unit? They say yes, and then all of a sudden they didn't realize that they can't move in until the next academic year unless they do a buyout agreement, and then it becomes that much more expensive because the tenant attorney knows that they don't get displaced until springtime. And it's not unusual for me to reach out
after I've been hired, after a mistake's been made, and I call up the opposing counsel, they say, yeah, Mr. Bornstein, they're happy to move out. Waive the rent and they'll move out the end of next academic year, right? Because no parent wants to start scrambling right now to find another school district for the August date. So you're stuck. And these are the type of things we face. Now let's talk about a couple other points. ADU units. We are involved in helping people establish accessory dwelling units in their properties. It's a very interesting opportunity. I just have to tell you this. You gotta deal with the tenants who are parking and storing in that space before you go through the process. We are getting into a particular jam if you're trying to remove parking while simultaneously seeking to install an accessory dwelling unit. And so all things being equal, we're offering money for people to give up their parking space in order for an owner, before seeking the permits, to actually try to sever that housing service, because a tenant who has parking can be a wild card to prevent you from putting an accessory dwelling. So what you want to do is negotiate a deal for the tenant to leave the parking, giving up the parking, so that you can actually install your ADU in that location. If the tenant has parking and they're not going to be acquiescent, they can stop the process from occurring, and you will be in a position where the tenant's right to park trumps your right to put in an accessory dwelling unit. So what we're doing is offering tenants money to give up parking, or finding alternative parking for a tenant and paying for their parking outside of the city.
But isn't parking part of their lease now?
Yes.
Are you breaking your lease by?
It used to be you could serve a notice of change of terms of tenancy, removing parking and severing a housing service if you give a substantial decrease. Now, so if you give a reduction of the rent, if they went to the rent board, they can say, hey, you took away my parking, I'm entitled to a reduction. Now the problem is if you take away parking and you don't have a just cause, they won't let you get the permit to put in the ADU unit. And the tenant has a disclosure right to learn about your intent to put in an accessory dwelling unit, and you have to disclose whether you're going to be removing or severing any housing use. So the conundrum is this: the city has a housing crisis. Owners are willing to put in ADUs and be subject to rent control on them, but a tenant's parking trumps your right to put in an extra unit. So, you know, with one tenant, we paid them $10,000 to give up their parking simply because of a client's desire to actually put in the parking.
So then that constitutes that violation is the agreement that stipulates that they have the right to have parking. So if you're buying them out, then that would substitute that.
A buyout would be a complete release of claims. So they're voluntarily giving up possession of the unit in exchange for compensation, and that's perfectly permitted. And the reason why I say that is, until you figured out where your space is going to be in that building that you're putting in the accessory dwelling unit, and that no one is inhabiting it, either for storage purposes or for parking storage, for parking purposes, you still haven't been able to actually be comfortable that your work, time, and energy is going to lead to actually the city giving you the right to actually put in a unit. And I've had clients in the process, for a seismic retrofit, we know we can sever the housing service, but the tenant has the right to come back. For an ADU, you really don't have that sort of permissiveness of temporarily displacing. And if you just lock the person out of their parking or storage, you can be sued for wrongful eviction.
You still have to file the notice to buyout for
No, I don't file it because you're not giving up the tenancy, you're giving up a part of the tenancy, which is different than a surrender of possession. And yet a tenant can always negotiate giving up something that isn't the full scope of their tenancy. And this is what they're recommending, which is the discretionary review process. They say, look, you need to negotiate with the tenant to figure out a way that they're going to not object to the ADU because you can sell their parking. I can take away parking, for instance, and this will generate a lot of questions, but if you got a duplex and the tenant on the ground floor has parking, and the owner wants to do an owner move and eviction, and there's only one parking space, I can do an owner move and eviction up top. Under the ordinance, I can't sever that parking space. I have to have a just cause to do so. What is the just cause if an owner's moving up top for severing the parking space from the tenant down below? the owner is going to use that parking space. So I would serve a notice of change in terms of tenancy, I would give a tenant a reduction in the rent, and I would articulate that the removal of the parking is because the owner desired to actually use that parking for their own use. All things being equal, I'd rather have a dialogue with the tenant and say, hey, we bought it, we're going to live here, you're welcome to be downstairs, we just need your parking, we're willing to negotiate a $200 reduction in your rent for the purposes of parking, and then you have the decision as to whether you're going to have a fight or not. But
We converted the unit as illegal in-law unit to an ADU unit.
yeah, you can. You can convert an unauthorized in-law unit to an accessory dwelling unit, subject to certain limitations, which is it has to be functionally able to meet some of the housing code requirements in order to do so. And if you're displacing a tenant in order to do a upgrade of the unit to meet the ADU standards, the tenant has the right to do that and come back in. But
For an ADU unit, if you put that in, it's in a single-family home. It's not treated then as a two-unit building.
I was going to point that out, which is you have a single-family home. You put in an ADU unit into a single-family home. What did you make it if it was built before 1979? 2 units, subject to rent control, just cause eviction rules, and protected tenants. So ADU units, they're really wonderful for a three-unit property or more, 2-unit property potentially, but a single-family home is kind of like fool's gold. You may have that rental income, but now you've subjected the house to rent control, just cause eviction rule, and protected tenant risk. Things will change depending upon what happens in Sacramento. Because if Sacramento imposes a new component of rent control on single-family homes, we may not, it may be attractive to put in accessory dwelling units. My general approach is if you've got extra space in a single-family home, embedded in the single-family home, and have only one lease agreement, if you live in the single-family home and you have extra space, roommate agreement. An owner who resides in the same unit as their tenant can terminate without just cause. But the roommate agreement on an accessory dwelling unit, if that tenant doesn't have free access to the kitchen and other parts of the house, it may look like a roommate agreement on paper, but if it's acting like an in-law unit, you can guess that a tenant attorney is going to say, you papered over this. This is still a separate structure. So there's ways around it, but then we get into a lot of complexity, and it's usually an opportunity for you to have a half-hour meeting with me, and we can talk about what I would do and what I wouldn't do on that. And these in-law units are really tricky in the city.
Single family home, you put an ADU unit in, and you're using it for like what happens, so it's no rental, what happens there? Still a two,
I would-
a two-unit building situation.
I think you would still have 2 units. I think you would still have 2 units, especially if you get with a terrace or that extra unit to get another address, right? Because for me, the address separately metered and all that.
They don't get separate.
It's just remember, the tenant sees you coming and going separately in this space, and when you try to raise rent to market rate, they say, wait a second, there's another unit in the building. They go to the rent board claiming a lawful rent increase, and the rent board says, how many units in the building? And you say, well, 1, and I kind of hang out down below. Well, you just got all the documentation that you made it a separate unit, which means that you are outside of cluster lines. And here's the thing, is you invite me back, in 6 months, I may have to change how things are going to be discussed because the laws and flux in Sacramento is starting to sort of focus on these issues as well. But
Lots of properties are redeveloped. SB 11 applies to new construction only, meaning everything is new. You know, not part of the foundation or from the plan. Now, in determining whether it's a 1979 construction before or after, how is it viewed by the city when it's a redevelopment with an old foundation, or that foundation has to be gone? How's that work?
very, very good question. So oftentimes you may have a single family home that now is a duplex. Someone legally added a unit. Is that new unit going to be subject to the ordinance or not? The general rule is that if it's within the existing envelope of the structure, it's not treated as original construction subject to the rent order. So if you build into the structure, you've got the continuation of the rent control, just cause eviction rules. If you build outside of the structure, then that new structure, if you built on top of the roof and you added a unit, then that's outside of the ordinance. Then it would be treated as new construction. But I would tell you that I would be reticent to give you a hard and fast rule, because you may have a new certificate of occupancy for that unit, but the rent board's gonna say, well, where was it built? Was it built within? Did you dig under and take the storage and convert it? Or was it in fact new construction? Then change the fact pattern and there was a complete fire on the property, right? If there was a complete fire and you built it again and you got a new certificate of occupancy, that may be a different situation. Change the facts again. It was formerly an industrial building and you converted it to residential use. A lot of the 3rd Street corridor, you had these really beautiful shells. They were industrial and then they were converted to residential. That's new construction, because it's its first use for residential purposes. And so if you look at a new building that's newly residential, the fact that it was built in the 1920s for a cigar factory is irrelevant until when its first certificate of occupancy was issued to the property. When zoning changed, but it's just the fact that it hadn't ever been used for residential purposes. And then, for instance, you have a commercial warehouse that's being used for residential purposes. It's not legal for residential purposes. It's a warehouse. What is it treated as? Subject to rent control if we offer it for rent. So there's all these sort of nuances, and each one has a different little factor. Let me just stop for 1 second because we're about over at 12. I want to talk about COPA for 1 second. For many of you who are not going to be in the business of selling triplexes or more, then a lot of this is irrelevant. Those of you who have the benefit of being involved in the sale or purchase of 3 units or more property, COPA has passed. You need to watch the law as it evolves. But right now, the general rule is the law has passed. It's not being enforced right now because the mayor's office still needs to qualify nonprofits and get that list together. That's likely to happen in September. And if there's no challenge to the law, in September, the list of qualified nonprofits will be out. And then if you are intending to market a 3-unit or more property for sale, you must first send notification to the qualified nonprofit list that you're intending to sell this property. They have a right to enter into negotiations with you before you present it to the open market. If you don't get to a deal with the interested qualified nonprofits, you're free to market it to the private community, private buyers. Once the private buyers make an offer, what you have to do to those qualified nonprofits that suggest that they were interested in the purchase, they have a right to what? Match the offer.
So
Yes.
will there be a database of some sort, so you have clients that are?
There will be a database of qualified nonprofits, and you're supposed to e-blast all qualified nonprofits your intent to market the property for
How do we
sale.
acquire that? How would we acquire it?
Oh, you'll get some San Francisco Association
Okay.
papers. It will be published. And the problem with the way that this protocol has been set up is this. If I'm a qualified nonprofit, I may express an interest anytime a 3-unit property goes out for sale, not because I'm going to buy it at the start, but because I have the right, if I express an interest at the start, I have a right to do what? Match any offer. So what you've done is, for all of you agents, making such a cumbersome process. It's not just an option to first right to purchase. It's also a right to manage an offer, which means you got 2 engaging events with the qualified nonprofit. And the assumption is most qualified nonprofits may not be interested, but an entrepreneurial qualified nonprofit who realizes that they have a chance to look at every 3-unit property in the city as to whether they're going to match an offer, they could hook up with a nice New York-based company that has a lot of investment opportunities and turn around and pick off a bunch of properties simply because they get to look at every deal in the city once they've expressed an interest, and they get forewarned about your desire to sell. So that's a little dialogue. I think
that there's gonna be a challenge to it. I just don't know when, and it's certainly not gonna be because I do whatever tenant law.
When did that come back?
Well, here's the thing, landlord-tenant law is becoming so niche specific, where you say, oh, he's a landlord attorney in the city. You have to ask this attorney, do you do owner move-in terminations? When was the last time you did an owner move-in termination? Because what's happening is it's becoming so cumbersome, there are attorneys who are self-selecting out of some types of terminations because they're just they're too time-consuming and they take a bit of focus that their practice doesn't necessarily necessitate it. So that's me for an hour. I appreciate it. I'll stay by for more questions.
Thank you very much.
Materials, just email me. I have my business cards here. I'll gladly send all of this by email.
Okay, you understand everybody? I think the only thing you need to remember is who are you? Yeah, really. Because this is too much. Isn't it crazy? It's too crazy. Every time I hear you speak, I think, forget about it. That's COVID.
Now I know just enough to be dangerous.
Now we can really go out and look at this.
Yeah, exactly.
You know, I think he's so nice to come here and he works situation, but he clearly will get tired. So this, I mean, oh, darling, wait, you know what? You know, I think I have to say, I don't want to. So, how are you? I was going to leave